I welcome you. I welcome to our global webinar on international contract drafting. I'm Aishwarya and I will be your moderator for today. So this webinar will cover key aspects of international contract drafting. Guys, please ensure that your mics are muted to avoid any background noise. And if you have any questions during presentation, then you can use our chat function. Okay. So we'll be having separate question and answer session for that. Okay, so now I am very excited to introduce our speaker for today. Chijioke Ibeku sir. Hello sir, how are you? And I welcome you to our innovation school.
All right. Thank you very much. It's a pleasure to have to be here with all of you. Thank you for inviting me. Thank you very much.
Yes. So, sir is certified mediator, lawyer, and author. He's founder and principal partner at Three Says Mediation, which is International Institute of Arbitration. Okay. So, sir, we all are very eager to hear from you. So you can start now, and floor is yours. Thank you.
All right. Thank you. Thank you very much. It's actually Three C's Met Mediators, and
Okay.
Three C's Met International Institute of Mediation, Negotiation, Counseling, and Conciliation. So it encompasses all the ADR mechanisms, all the tools in the ADR mechanism. My name is Chijioke Nnanna, a lawyer, and I'm an author. We've written books about mediation and about property management, where we will try to emphasize the importance of mediation. When you reached out to me, when two of you reached out to me, I almost declined. I almost said no, because I was wondering, well, how do I bring in mediation? And suddenly it struck me that yes, I can talk about mediation in this international contract. In fact, it is very key. And where I'll be relying on is the Singapore Convention. But be that as it may, I will hold on until we get to that point as highlighted by me in the bullet points I sent to you. I asked a question initially. I said, are we all lawyers here? You said yes. Are we some are lawyers, some are law students? Now, contracts. You know what contract is all about. I just talk about the ingredients, offer and acceptance. You know the consideration, you know the capacity, and you know the legality. So you can imagine doing contracts across the borders. I'm in Nigeria and you're in India. So you have to take into cognizance the offer. You have to take into cognizance the acceptance. You have to take into the consideration, the amount of money. And all these things can brew a lot of issues. And that is why one is very particular and very careful when you're involved in international contracts. Having said that, I'd like to talk about what international contracts is all about. International contracts are agreements between parties from different countries that govern cross-border transactions. Cross-border transactions, international contracts are agreements between parties from different countries that govern cross-border transactions. And when what are the cross-border transactions? You're talking about how much you're willing to make for a transaction, how much are you going to pay for it? What is the law guiding? What law will guide that transaction? And these are issues, if not well managed, can cause a lot of problem in international relations and, of course, international contracts. Again, the international contracts also involve sale of goods, services, intellectual property, and other business agreements, typically governed by combination of domestic laws and international treaties. So you're taking into cognizance in international contracts, you're going to take into cognizance what are the laws operational about a particular business in Nigeria, for instance, and what are the laws about a particular business in India. So you're going to know which laws are going to apply. Are we going to use the laws of India? Or are we going to use the laws of Nigeria? Now, because the laws of India might not favor me, who is a Nigerian, you need to adopt a law that will cut across both Nigeria and India. So that when you're doing international contract, you're not going to be worried about what laws are operational in India or what laws are operational in Nigeria. Because I said the laws in Nigeria might not meet you well in India. And of course, the laws in India might not meet you well. So you need to go for a common law, a law that will cut across both India and Nigeria. And that is where you have the Singapore Convention. And that is where the beauty of mediation that I profess and profile across the borders comes in very handy. You now have to talk about Singapore Convention. The Singapore Convention is all about making sure that you and I can do our businesses in our different countries, but we have a common law that binds us. We have a common law that binds us. So, in other words, if I'm doing a business with you, my dear lady, you will make sure that yes, Nigeria is a signatory to the Singapore Convention, so is India. So, whatever laws that will be applicable to us has to be a law that both of us have agreed to. And of course, as lawyers, and I'm sure you're all lawyers here, you know what it means to domesticate your law. So Nigeria is a signatory to Singapore Convention, and I believe India is. So there'll be no problem of saying which law will be applicable. What are the guidelines for a law that will be applicable to the business we're going to do? So by virtue of that Singapore Convention, we already have a law that cuts across both India and Nigeria. Again, we all know as the name domestic contracts. I like to talk about it. The domestic contracts are the ones that you handle within your spaces. Within your own country, like I'm in Nigeria, you're in India, the domestic contracts will be how do we manage our contracts within. But remember, you cannot talk about international contracts without talking about the domestic, because it's the law I have. The law that is operational in Nigeria is what I will bring forward when I want to transact. But because it's an internationally centered contract, I now have to take into cognizance the law that will be okay for me as a Nigerian, as you as an Indian. And that is where Singapore Convention, particularly for commercial transactions, comes in. That is where international, I'd like you to take home, if nothing else, remember what I said about the Singapore Convention. The Singapore Convention, it is a particular convention that us mediators, particularly who are involved in commercial transactions, have used to make their international contracts seamless. Again, I'd like to talk about the risk factors. I like to talk about risk factors. One of the hazards of international contracts is a risk involved. Is a risk involved. And of course, the risks are generally limited to local, economic, and political factors with respect to domestic contracts, risk in international contracts. Risk in international contracts. Differences in our legal system, as I earlier on highlighted, the currency fluctuation, political instability, and these are risks. I could do a business with you today. Today is Friday, 2024, 30th December, 30th August 2024. The dollar, the Naira exchange to the Indian rupee might be 2 Naira to 1 rupee. If we have a transaction 2 Naira to 1 rupee, and we don't tidy up that transaction as and when due, if we don't tidy it up in August, and we are holding on for that transaction to be tidied up in August, in December of 2024, we might have a problem because of the fluctuation in our currencies. So these are risk factors. So you have to have a law that takes into cognizance all these risks. What would I do for Mr. A that will be okay for Mrs. B in India? Or what I do for Mrs. B in Nigeria that will be okay for Mr. A in India? All these are risks. The political instability, the differences in our legal system. There has to be something that cuts across the two systems to make it worthwhile getting involved in the transaction in the first instance. Again, I like to talk about the legal framework and jurisdiction, importance of identifying applicable law. If you do not have a law, if you enter into a contract internationally and you have no law that is applicable, and both of you, for any instance, are not signatories to a common law that will hold the two of you together, and I've given an instance of where the Singapore Convention has taken care of that. But if there was no law, if that petition very void, nothing is on paper, it will be assumed that wherever the transaction took place, that is the law that will be applicable. So if I went to do a business transaction, maybe I had a business transaction that was emanating from India, and there was no law, I did not say, okay, you're not saying, Mr. Chijioke, which law will be applicable? Or my friends in India, which law do you, nobody had a law, a specific law that was going to be applicable. Then what invariably means that wherever that transaction, the place that that business transaction took place, that is the law that we'll use. That will be the law of that country will be the law that will bind our business. So in other words, if you're not specific, if something is not, in this is international draft, this is all about international contracts. If something is not specific as to the law that will be applicable for a transaction, if you do not specify it, if you're not saying it's not going to be Nigeria, if you're not going to say it's not going to be India, if both of us are not signatories to the Singapore Convention, then it invariably means that wherever the transaction took place, wherever it took place is where the law is the law of the place that will govern that transaction. What again? I want to talk to you people. Okay, I talked about that. Just pardon me. I wanted to look at something else that I feel that is very necessary. People will have to share and know. Can you hear me? Hello, can you hear me?
Yes, sir.
Yes, sir. You're
Yes,
audible.
Okay, when drafting international contracts, parties should consider incorporating mediation. You can say, why not arbitration? A lot of people have seen that arbitration is almost as technical as litigation. And that is why those of us in our humble spaces are preferring for mediation. And that is why we've also, highlighted this Singapore Convention I mentioned to you. People say, oh, why the next thing to do is, why don't you do arbitration? Why don't you create a room for arbitration where awards are created? After all, it's an international business transaction. But the Singapore Convention has made it very viable for us to recourse to mediation. And it is very binding and it's almost seamless. You and I don't know how much exposed you are. You can see that arbitration is almost as technical as litigation. And these days, people are tight. They have limited disposable funds, a lot of uncertainties. People cannot imagine being in court forever. I don't know how. I know, because I have some friends from India. I know that your judicial system is almost as bottlenecked as ours. Things are not done speedily. You have a lot of adjournments. So people do not want to, no businessman will want to do a business in Nigeria or India and want to suffer adjournments unnecessarily. He or she wouldn't want that. So they want a business transaction that will make their business seamless. And that is why mediation is always incorporated. And that is where the Singapore Convention is very key. It makes it very easy for people to talk, begin to do their businesses, and know how to, meander and navigate through their businesses without having so much of bottlenecks. In some of these developing countries, like Nigeria and India, you have a lot of bottlenecks, bureaucratic bottlenecks. Under my accent. All right. Somebody was saying he doesn't have to understand my accent. Okay. I like to take it easy. We've talked about international contracts. I hope you understood that. And I've said, okay, good. Okay. We've talked about international contracts. And I've said international contracts is about having two people from different countries try to do a transaction. Now, if you have two people doing contracts, for instance, I'm in Nigeria and you're in India, which law would be applicable? Which law applies? I'm a Nigerian. I do not know much about the laws of India. You're Indians. You don't know the much laws of Nigeria. So we have to find a law that will be applicable. And which laws are those? That is where international contract comes in. Now, the Singapore Convention has taken into consideration that two people are from different countries, yet we still have to have international contracts done. How do we do that? Now, how we do that is by making sure that we domesticate that convention. To the best of my knowledge, Nigeria has domesticated the Singapore Convention, so has India. So it means I can transact businesses with you as Indians without having any fear of which law will be applicable. The Singapore Convention, I think, is 2020. I think it's 2020, 2020, 2021. 2020, 2021, Singapore Convention. Is either the year 2020 or 2021. India has domesticated it to the best of my knowledge, and Nigeria has done so. So we don't need to worry about how to do our draft, which law will guide our draft when we do it, because we know that both of us are signatories, our countries are signatories to that convention. Now, I now give you another instance. I'll give you another instance. I say, if I want to do a business with you as a group of Indians, and there is no law applicable, maybe there was nothing like a Singapore Convention, we do not know what law to be applicable. Now, the law where the business was transacted, assuming I was going to come to India to manufacture goods in India, and I want them to be transported or shipped to Nigeria, it invariably means that it's the law of the Indian law that will guide our business transaction. It's the Indian law that will guide our business transaction, because it is the law of the way the business took place. And remember, I said, assuming there was no specific law, then the law of the place where the transaction took place will be the governing law. And again, I wanted to bring another very major issue to take into consideration in international transactions is the risk factors that are antecedent to some of these businesses. Number one, we already know that one of the major risk factors is the legal systems, difference in legal systems. But we have seen how I have addressed it by using the instance of Singapore Convention or by using the instance of wherever the business took place. Number two, you have to take into consideration the currency fluctuation. I use the Naira, you use the Rupee. The Naira and the Rupee are on different terms economically. So we need to find a system that if I'm buying in Naira, if I'm going to buy in rupees, I'm not going to be making so much of a loss. So there has to be a common law, something that will make it worthwhile for both you and I who are internationally transacting. So these are the risk factors that one has to pay attention to. Again, political instability. If a policy that had made it friendly for you to invest in Nigeria is no longer friendly or will no longer be friendly in 2026, how do we go about that? These are considerations you have to be very particular about when drafting contracts. You do not have to draft contracts in the dark. There has to be something you can lay hold on. You have to take into cognizance some factors that are that almost play out every other time. Are you going to draft a contract in 2024 where the policies are very friendly, and in 2025 the policies might not be friendly to you? How do you cover up for any loss that might emanate from that gap? And this is what international contracts you have to be very mindful of. This is what it takes into consideration. Again, having said that, I'd like us to begin to exchange views and questions so that we can further expatiate or expand the class more. Thank you very much.
So guys, if you have any questions, you can ask him. You can unmute yourself and ask the question.
Hello. Hello.
Yes, tell me.
Yeah, I have one question here. The topic is regards to the contract drafting. So, as per the amendments later, whatever the amendments are, the contract drafting definition, does it include the industry with the other types of the industries, like including IT industry also? This is my question.
Yes. If you listen, I don't know when you joined. If you listen to me, I said it involves the international contract drafting involves sale of goods, services, intellectual property, or other business arrangements. So any business that has to put into a contract that two people from different countries sign, it's already an international contract. And international laws will be applicable. If there are no international laws specified, the laws of the place where the contract took place will be applicable. So it involves what you just mentioned, intellectual property. It does involve it. Thank you very much.
Sir, I have a question. Like you have said that international law will be applicable while doing the any sort of IP contract or sales of goods contract. So basically, you are talking about international law of which, like which specific, uh, you means organization, which specific organization means like for example, if you are doing any kind of intellectual property interaction or some kind of publication or some kind of exchange, bilateral educational exchange. So now which specific organizations law will be applicable there?
If I understand you correctly, now what happens in most international contracts that you do is, for instance, what will I use now? If we had which example will I bring home more? Okay, I like to use, maybe maybe you're dealing on land. For instance, you need to buy a particular land. You want to do an investment in Nigeria. Maybe you're involved in one of the networks, maybe one of the networks, MTN or Airtel or any of these networks, telecommunications. Now, what we are trying to profile in this session is that the international standards that have been domesticated by India and Nigeria will be applicable. So, for instance, if we say that there's a common line of business or law guiding the businesses between me as a Nigerian and you as an Indian as regards the telecommunication, that law will be what will be applicable. It will not be specifically the law of the Indians or the law of Nigerians. It will be the internationally best practices that has taken into consideration your law and my law. I can't quote that offhand now, but I know that the Singapore Convention has provision. It's for you now to make your detailed study. Has provisions for businesses as relates to commercial transactions between parties, international parties. Thank you very much.
Thank you, sir, for clarification.
Yeah, I have one question, another question. That is, suppose the two parties to the contract, they are on the offshore or they are in the airways, and they are having any contract to be taken place. There is any contract taken between both the parties. So one is from the domestic and the second is from the international. So which law will be applicable for both of them?
I missed out that question. This is a very interesting question. Could you repeat, please? Could you repeat? Come again with that question. I missed it out. Could you come again with that question? It's an interesting question, the much I could hear, but I lost it out on the particular point. Could you repeat it, please?
Hello.
Yeah, I am not getting you. Can you repeat once again?
I said you asked a question and I lost track of the question. Could you repeat that question, please?
Yeah, okay. I mean to say that if there are two parties who are in relation to the contract, and one is from the domestic area and the another is from the international. Like for example, anyone from India and the another one is from US or any other country. And if they are on the offshore or they are in the plane together, and if they do any contract between both of them, then will the domestic law be applicable for them or only international law? That is my question.
Very good. It's international law because if I had carefully know if when I started, I said any transaction, anything that is not like for instance, if you're in the airspace, if you're in an airspace, if you're in an Indian airspace, and something happens, some God forbid, anything goes wrong, and there's no specific law to guide whatever transaction takes place within that airspace, the Indian law will prevail. That is a domestic law. But if within that airspace, the two countries have said anything that happens within the Indian airspace, if anything goes wrong, whether you're Nigerian, whether you're Pakistan, whether you're an American, that what will be applicable will be the laws between the international law binding the two of you. Then the international law will be applicable, will be the binding law. In other words, I'll give you an instance that one of the international laws that is very binding, once your country is a signatory to it, it means it's applicable to you. You're bound by it. I hope that answers your question in some ways. Thank you.
Hello. You mean to say that if both the parties are in Indian jet, for example, so the law will be applicable, and if they are moving to US, both of them, so the law will be applicable of domestic of India? Which airspace?
What I said, for instance, if you're two of you are in an Indian jet, you're a Nigerian and an Indian is in you're a Nigerian, for instance, and an Indian is in that jet, and anything goes wrong within the Indian space, and there was no law specified ab initio before whatever happened goes wrong, then the Indian law will prevail. But if there was a law ab initio, if there was a law prior to whatever happens, and says if anything goes wrong, that is the international law that will be binding, then both of you are bound by the international law, regardless of where whatever happened took place, or regardless of the fact that it's an Indian jet.
Okay, good, thanks. Okay, good.
Any other questions?
Yeah.
So there's one question in chat box. Can you please address that? Question from Ebenezer.
One of the things about that, the question I saw in the chat, you should always make sure how enforceable is it? Enforceability. If it's not going to be enforceable, then it's practically useless. Anything you're doing has to be enforceable. It has to be something you can have a feel on. It's something that has to be, that can be dealt with. You're not going to make laws for the abstract laws. You're going to make laws that are enforceable. I don't know if that, I think that should answer the question of the gentleman or lady that asked that question. Thank you.
Okay. Thank you so much, sir. That was incredibly insightful. And I thank